Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, can a guardian create an estate plan on behalf of a ward in Illinois? So if a disabled adult lacks the mental or physical ability to make decisions for themselves, they can have a guardian appointed for them by the court, who then gets the ability to make these decisions, and those decision-making capabilities that the guardian has are removed legally from the disabled adult. There are two types of guardians, guardians of the person and guardians of the estate. Guardians of the estate are responsible for financial decisions on behalf of the disabled adult. Guardians of the person are responsible for non-financial decisions like health care, the personal care and needs of the disabled adult. So a guardian of the estate is empowered to create an estate plan on behalf of the disabled adult, but they have to go through the court to do so. So a guardian of the estate can't just execute a will on behalf of the disabled adult and have it be valid. You need to get court approval of the will or trust that's executed on behalf of the disabled adult. In creating the estate plan, the guardian has to take into account what the disabled adult would have wished to do with their own estate plan. Not necessarily what the guardian thinks the best thing to do would be, but what the disabled adult would have done to the extent that's ascertainable. If the guardian can't figure out what the disabled adult would have done, then the guardian can act in the best interests of the disabled adult in creating the estate plan. So this is called the substituted judgment standard. You're substituting the disabled adult's judgment for your own if you're the guardian. So, for example, if the guardian knows that the disabled adult would have liked to have given a bunch of their money to a particular cause that the guardian disagrees with or doesn't think is a worthy use of that money, then they still have to give the money to that cause in the estate plan based on the substituted judgment standard. So when the court reviews the estate plan that the guardian has prepared, they're going to consider a bunch of things to determine whether this standard is met. First, and most importantly, is whether the estate plan is set up in such a way that the ward's current and future needs are properly provided for. Second is whether the estate plan provides for the ward's children, grandchildren, and other close relatives. Another factor is whether the ward was estranged from any of their close relatives. So if the guardian knows that the ward was not on speaking terms with one of their children and has a great relationship with the others, then the guardian can assume that that child would not be part of the estate plan and would not inherit anything and create an estate plan in such a way, and the court will honor this. A big factor that courts consider is the minimization of estate taxes and income taxes, provision of gifts to relatives, friends, and charities that the ward would have provided for, and the ward's wishes to the extent that they can be determined from conversations with the ward, previous estate planning documents, or any other evidence like listing of beneficiaries on life insurance policies and 401ks. In creating the estate plan for the disabled adult, the guardian is given a lot of powers to do certain things. They can create revocable and even irrevocable trusts that extend beyond the life of the ward. They can update insurance policy beneficiaries, retirement account beneficiaries, and do most of the things that the disabled adult would be able to do if they were creating their own estate plan. They can even update previous estate planning documents that the disabled adult had created, but this is kind of limited not usually to disinheriting people, but to updating them to reflect changes in tax law that will be beneficial. So the process is basically that the guardian prepares this estate plan, files a petition with the guardianship, well, it's the probate court, but the case that has jurisdiction over the guardianship case, or the court that has jurisdiction over the guardianship case, to have the estate plan approved, and then the guardian will have to demonstrate at a hearing that the estate plan comports with the substituted judgment standards, meaning that this is what the ward would have wished to have been done if the ward were of sound mind. Now, something to bear in mind is that just because a guardian is appointed for a disabled adult doesn't mean that the disabled adult lacks the ability to make their own estate plan. Testamentary capacity, which is the ability to create a will or a trust legally, is different from a legal disability that may require a guardian. They're different standards. So in order to have testamentary capacity, the ability to create a will or a trust, you have to know who your children and grandchildren are. They call this the natural objects of your bounty. You need to be able to know what your assets are at the time of creating the estate plan and what you're doing in creating the estate plan and what the effect of what you're doing will be. If you can have the mental and physical ability to understand those three things, then the ward can create their own estate plan without the guardian being involved. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, please give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com. Call us at 630-324-6666 for a free consultation.